afternoon. Welcome to a very special edition show of the Law and Crime Network here. I'm Michael Bryant. Welcome to, of course, Demelly's 4 million followers. I know I've tuned into this case to find out if their followee is guilty of a double murder or not. And I'm telling you right now, YNW Melly, this case has drawn quite the attention. Court is dark today, but it does resume on Tuesday. Remember, Monday is the holiday. This is the case. Just if you haven't been here for this week, first you missed a lot, and we're going to get into that. But this South Florida rapper, whose real name is Jamell Demons, he's on trial. It's Broward County, Florida. He is accused of double murder in the deaths of two people, supposedly his friends. Those two counts of murder, first degree, took place 2018. These are guys that some say were his buddies. Christopher Thomas, also known as Juvy. I'll tell you right now, YNW, I'm taking judicial notice of it. We'll ask you to do the same. Just assume I'm saying YNW every time. I'm just going to use the rest of those names. Juvy, that's one of them. Anthony Williams, known as Sakchaser. Those were the two that were shot that night. Now, the defendant and the victims were all part of this collaborative that was in the music business, right? So they're out one night, they're cruising around, and at that point, that's where the story changes a bit. It depends on who you believe. Prosecution basically says that the defendant, Demons, shot these two guys, killed them. They were in the same car. If you believe the defendant, it was a drive-by, and he had nothing to do with it. So those are the parameters of this case that we've been following, and it is fascinating. So a busy day in court yesterday. We're going to do a Q&A for the next couple hours because I know you've got questions. As this case began to unfold, I could just tell that the keyboards were clattering. So we're going to get to your questions. If you haven't done so yet, YouTube, et cetera, anywhere you want to send those through social media, we will go through those questions and answer as many as we possibly can. But yesterday on the stand, Felicia Holmes, the mother of the defendant's ex-girlfriend, she took the stand. It was quite interesting. It was, some would say, hostile, even on direct examination. After the witness was excused, though, the defense made a motion for mistrial. So let's hear exactly what happened in this Broward County courtroom. This was yesterday afternoon.
Jury's been excused. Counsel remain along with the defense. So you have a couple motions for mistrial. You want to talk about those?
Yes, sir. As sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do, advanced a ruse pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to Plan 1, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Demons has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what that might
This is your motion for mistrial, Mr. Addison?
Yes, it's our motion for mistrial.
This is the second one. All right, go ahead.
Well, second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper, and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text. Couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since. So just to let the court know, there is no factual predicate for the implication, or not implication, the accusation made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her.
Okay, so some pyrotechnics there in that Fort Lauderdale courtroom, and the idea being the prosecution was inappropriate in how they used a witness to the defense's detriment. That's the basis of the motion for mistrial, which is obviously an extreme remedy. The question is whether it will be granted or not. At this point, we just don't know, but I got some good folks here to talk about this, and we're going to have our Q&A sessions. Oh, Terry Austin is here, and am I okay? Am I sitting up straight? Because anytime Terry's in studio, I know that it's serious stuff. Terry is here. She's, of course, with Law&Crime. Bradford Cohen is with us. He is Melly's former attorney. And at the courthouse, Bryson Paul, he is there in Fort Lauderdale. Thanks all for joining. So let me start with you, Terry. Making a mistrial motion, not a surprise for a defense team, but this one seems pretty serious. What's your take?
I think it is very serious, and I think the judge is seriously considering whether or not this mistrial should be granted. The defense really, I think, put up some great arguments saying that the information that they were trying to get in was barred because of hearsay, basically. And there were two main arguments they were making. One was prior inconsistent statements, and the other one was prior recorded statements. And for various reasons, the judge agreed with the defense that it shouldn't come in. Some of the issues were the fact that it wasn't under oath for one of the statements, and the fact that it was hearsay for a fact, and then the prior recorded, it wasn't close in time, and that it wasn't accurate. So the judge agreed. And the judge did say, as you heard in that clip, that the defense was right and that the prosecution should not try to get in the back door what they couldn't get into the front door. So good motion on the defense side. Judge told everyone to make sure that the defendant knew and understood what could happen with a mistrial. So we'll see what the judge does.
Yeah, that's the old backdoor. I mean, attorneys make their living for the most part on how to get something in that they couldn't get in one way. The question is, did they go too far, and did they push to the point where it was in fact prejudicial to the defense? Hey, on the ground there, Bryson, what was the reaction in the court as this was unfolding?
A lot of unsettled between the victim side of the family, and a lot of peace and calm for Melly's family on the other side. It was definitely a lot of tension built up throughout the days leading up to the fourth day of this trial, as trial is set to begin return on Tuesday, June 20th. But it was a lot of tension that built up from day one all the way to day 4, and that was easily visible between both sides, with the victim's family very angry, very upset by the way Melly had his posture, him praying, him doing everything other than being remorseful for the loss of his best friends, YNW Juvy and YNW Sakchaser.
Yeah, there's quite the crescendo to the first week, this motion, and it still hangs in the balance. Hey, Bradford Cohen here again, former attorney for Melly. Let me ask you this. What was your involvement with him prior to this trial? And then give me your take on the legitimacy of this motion.
Sure. I was hired on the murder case along with Jason Williams. Jason Williams is now the state attorney in New Orleans. So we were on the case for about 6 months. We saw all the discovery that was provided to us, reviewed all the discovery, had a defense strategy. And I think this defense is doing a very good job with the strategy. The same strategy that we had is that, they have all this information, ballistics, phone records, things like that, but they don't have anyone that can actually say that he was in that passenger seat at the time of the shooting and that he pulled the trigger. That's the difficulty in this case, is that there's a lot of technical evidence, but not a lot of eyewitness testimony, because his co-defendant, as you know, is severed, meaning he's going to be tried separately. So when you have co-defendants that are tried separately, generally speaking, each one will point the finger at the other one, and it's very difficult to have one of them convicted on that crime. That being said, this motion I thought was well thought out. I thought it was well done. I know both attorneys, and I've spoken to both attorneys in this case. I think they're both quality attorneys. They know what they're doing. They've tried big cases. I think that in this instance, they did a very nice job laying out. If the judge denies the mistrial, you have to think to yourself that there's going to be a great appeal if a conviction comes through. Mistrials are such a difficult thing for a defense attorney, especially when you feel like the matter is going in your direction. So trials, like football, are a matter of momentum. And I think that the defense has been building momentum since day one and has been doing a nice job. So now you're at this point where you're doing a nice job, and the state either purposefully or unintentionally does this thing. And it's hard to say that it's unintentional. They knew what the rules of the game were. They knew what they were allowed to do, and they broke those rules. And they broke them very significantly. So when you're a defense attorney, you almost don't want to move for a mistrial, but you have to, especially in a case like this, where it's so significant, where you're facing a possible death penalty. And in Florida, the death penalty rules have been changed from unanimously to essentially a majority of 8-4, where the juries would vote for to implement the death penalty. So it's such a huge case. You can't not move for a mistrial. You really have to in order to preserve the appeal. But do they really want the mistrial? I don't know. I wouldn't, because I think that things are going in their favor. And we'll have to see. If it doesn't happen, they're going to have to start over from square one, pick a new jury. And now the state gets to kind of see what's going on, right? You get to see that card before they played it. So the second bite at the apple, they could clean up the case. They could now streamline it, and you'd never want that.
Yeah, it's almost like a preliminary hearing. Okay, here's our case. Maybe you can fix it next time. And real quick follow-up, Bradford. The judge could Tuesday morning rule, and this thing is done for now.
Yes, the judge could certainly grant the mistrial. And if the judge grants a mistrial, then it would be done. They'd pick a new jury. Like I said before, now in playing blackjack, the whole thing is what's the undercard, right? What does the dealer have? In this case, now you kind of know what the dealer has, and you can play your hand in a different direction. So generally speaking, mistrials really benefit the state. That's why it's such a horrible thing, right? So it's their fault. It's intentional or unintentional. In this case, I think it was intentional. And now they get the benefit of it. Now, if they could prove some intentionality and they can make some sort of argument why this case shouldn't be tried again, it's very difficult to do that. But they could try. I don't think that would happen. I think that this would be a retrial, and I think the retrial would be in another couple weeks, and I think they'd pick a new jury and they'd start over again.
Well,
but it's, like I said, it's a very difficult decision.
Yeah, we're going to find out. Now we can stew over the 3-day weekend as the judge is and see how this thing shakes out. We're going to take a break now. We have the Q&A questions all lined up. I've got them here. I've got Terry Austin, I've got Bryce, and I've got Bradford. Let's take a break. We'll come right back after this. So choose your weapon, whether it be YouTube, Facebook. Is MySpace still out there? Anything you find on your social media agenda there, send us your questions. We're going to try to handle as many as we can in the next hour or so. And luckily, I have with me Terry Austin, Law&Crime's very own. Bradford Cohen is here, former Melly attorney. And on the ground there, Bryson Paul. He is in Florida as this case continues against Jamell Demons. Let's go with the first one here. Terry, Shirley Girl from YouTube says, why the turtleneck every day? I think there's a little story behind that. What is that?
There is a story behind that. Apparently there's a tattoo on his neck, and maybe Bryson can tell us more about it, but it's the mom of one of the victims. And it seems as though defense counsel wants to make sure that the jury doesn't infer good or bad as far as that tat is concerned, and only listens to the evidence. So we've been told that he's wearing turtlenecks to cover up the tattoo.
And actually, it's a good look. I mean, it's a clean look. It's a professional look. So I think this helps him, regardless of what's under that turtleneck. Hey, we talked a little bit about this, Bradford, before we took the break, the mistrial. But a question here from Chris Larby from YouTube. Could Melly walk on a mistrial? And how likely is that? I'll let you handle that one.
Yeah, it's very unlikely that would happen. There'd have to be a massive injustice for the court to rule that it was, something that couldn't be mistried, that it was with prejudice, and that likelihood is very slim. Most likely, it would be a retrial.
Yeah, and a lot of that sometimes has to do with how far they've progressed in the trial. Yeah, we're day 4, maybe a third of the way through at the very most. Okay, question now for you, Bryson. This comes from Sonia W. That's not very creative, Sonia, but Sonia W. From YouTube says, this has to do with a factual issue that may be in dispute. That's why you can help with this, Bryson. Was Melly in the back seat of the same car as the two victims at the time of the shooting? Was he in the back seat? Was he in the front seat? What do you know about that?
That's a good question, Sonia. Look, so YNW Melly was in the left rear of the proposed vehicle that contained the drive-by, or that was proposed to be a drive-by shooting of and the loss of YNW Juvy and YNW Sakchaser, who were on the who were on the right and front and the right rear of the car, and who's proposed to have been sprayed with the drive-by. But at the same time, it's proposed that Melly wasn't in the car at all. He was in a second vehicle later on, after the group left the studio that night in Miramar.
So I know it's very disputed. I believe there's some surveillance showing him get into that rear left position in the subject vehicle, so that may be tough to dispute, but it is definitely a question the jury's going to have to wrestle with. Hey, Bradford, I'm going to load you up a little bit because I know I'm losing you at 12:30, so let me ask you this, and you may have some insight that others don't have. This is from Inate806 from Twitter. Do you think Melly is going to take the stand?
The likelihood is very slim. I don't think there's any real net bonus of him taking the stand. My theory would be for him not to take the stand at this point because it's not necessary. This case rests solely with the state to prove their case. And although they have video of Melly getting into the right rear passenger side from the studio, they still don't know at the time of the shooting if he was in that passenger side. They don't have the weapon that was used. They don't have DNA on Melly or Melly's DNA on a weapon. This is a very, although people keep saying like, oh, they have video, they have all these things, still a difficult case to prove because you have at least two individuals that were in that vehicle at the time of the shooting. You don't know if they stopped and they switched places. You don't know if they stopped and picked someone else up. There's so many questions that occur in terms of who was in the car at the time of the shooting. So it's I think it's a very difficult case for the state. I thought that from the beginning. If they get a conviction, I think that it would be something that would be hard worked for, because I just don't think they have as much evidence as people seem to think on some of the sides of this.
Yeah, and that position in the car is so critical, and it's really going to be up to the jury to decide, okay, is it logical that somehow he would have stopped, changed cars, changed position, or not? And I think that plays into the bigger story that was developed after the crimes and the suggestion by the prosecution that it was a staged drive-by that didn't really happen that way. Very interesting part of the process. Terry, let me ask you this question. And this is a common defense tactic, which is attacking the process of investigation. This is Briley from Twitter. Should the investigators get in trouble for their lack of support and not investigating more into things?
Well, I don't think they're going to get into legal trouble, but it's a good question. I do think that both the Broward County and Miramar Police, they're going to think about their policies, their processes, whether or not they could have done better, whether or not they could have gotten a search warrant to look at the house, whether they should have followed up with some of the statements of the defendants at this point. So I don't think that anyone can bring a claim against them, but I do think that both of these departments should take a look at how they investigate cases, because I think the defense made some very strong points during their opening and during the cross-examination of the state witnesses that the investigation was not solid.
Yeah, so maybe not anything legal, but
originally had the case, and I thought Miramar did a very sloppy job of this investigation. PSO did a little bit better. Miramar was, in my opinion, horrendous in the way they investigated this. But after this occurred, I was already representing Melly, and the officers all knew I was representing Melly. Knowing all that, they still tried to take a statement from Melly without informing me first. Obviously, I informed him that if anyone comes to give you a statement, you're represented by counsel, and if we're going to give a statement, counsel has to be present. And that's what he advised them. But they all knew that he was represented, and they still attempted to take his statement. So Miramar, I think, really needs to look at a lot of things when it comes to this case. Their policies is one of them. But also, when you limit yourself to looking at one defendant, one individual, and you sell yourself on that one individual and no other individuals, you really limit your investigation, and that's improper. And that's something the defense attacks. I attack that all the time.
Yeah, we see that, Brad. That confirmation bias. We see it. It's really maybe the rare case we don't see it, and so it's common to use by the defense. They're using it in this case, and as you suggest, maybe in this case even more outrageously than they might have. So again, these are all things the jury gets to decide. So we're going to keep following that issue, of course. Bradford, I've got to kick you loose. I appreciate so much you taking some time to help us go through some of these questions, comment on the latest, the mistrial motion in that trial. Bradford Cohen, thank you so much. Melly's former attorney. Hope to talk to you again.
Thank you. Thank you for having me. I appreciate it.
You bet. Terry's going to stick around, and Bryson's going to stick around. I'll stick around. Let's take a quick break. We'll come back for more in this case. Law&Crime, everybody. Taking your questions here, and the best part of this is I ask the questions, everybody else provides the answers. It's a perfect situation. We're talking about the case out of Florida against Jamell Demons, also known as Melly, a rapper, kind of an up-and-coming rapper when this happened. He was 18 years old at the time. Now he's 24, and in trial for the deaths of two folks that maybe were his friends, Anthony Williams, Christopher Thomas, both dead by shooting the night of October 26th. 2018. Defense says, hey, it wasn't me. It was a drive-by. Had nothing to do with it. The prosecution, of course, believes Mr. Demons did it, along with Cortlen Henry, who has been charged but will be tried separately. And we haven't talked about the whole severance issue and the impact on this case and on the Henry case to come. But it's huge. It's massive. So let's get into some of the questions and we'll get you some answers. If you haven't done so, hop on the keyboard there, YouTube, Twitter, whatever your favorite social media might be, and send us questions. We're going to try and get to as many as we can. Terry Austin is here, and also at the courthouse, Bryson Paul. Terry, let me ask you this one. This is from Katie Kang, YouTube. Could the girlfriend's mom, who we've heard Felicia Holmes talk about, she was the girlfriend's mom, could she face charges for her, quote, loss of memory and or possible lying?
Oh, Katie Kang, that's an excellent question. And I think we saw her on the stand and she was clearly afraid. She was intimidated by the prosecution because she could face possible charges of lying and obstruction and any other, charge that the prosecution might want to bring. She's trying very hard to cooperate and not incriminate herself. She hasn't claimed the fifth. She's been sort of, factual in an attempt to say something that makes sense, but there've been so many objections. It's very difficult to determine any sort of factual basis for what she's saying, but it's a great question. She could face some charges. She has apparently a ankle bracelet on, and she was at one point under house arrest, and so she's definitely in a position where she's got to be very careful not to lie and not to incriminate herself.
And it's always interesting when you see a direct witness, whether it's prosecution or defense, be hostile, because they're treated differently. You get a chance to treat them more like you're cross-examining them. The question then becomes, how helpful are they for your case, right? I think it's a good idea to take a look at some of that testimony, and then we'll do some more questions on the other side. Here we go.
Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, I don't feel comfortable.
Are you nervous?
I feel threatened.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
What the rules?
Christine Bradley in the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
You even went so far as to hire an attorney
Yes,
to
I
try
did.
not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal. The state has run my life.
And in terms of your feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
and does that influence your testimony today?
It's not influencing my testimony.
Have you-
I'm telling you.
Have you-
I
that's not-
don't
objection, Your Honor.
Excuse me, hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, Your Honor. So my objection was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued,
Yes.
you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you at the 4th District Court of Appeals?
He had to hire an attorney because he tried to get him this far.
And no, that's a false statement.
Objection.
That-
Excuse me, counsel, you're not testifying.
I
all right?
agree on that.
Excuse me, you asked a question, all right? That's it, you asked the question.
And so, Ms. Holmes, with regards to that, you hired an attorney
Yes.
and you then tried to get any sort of court order requiring you to be here in court thrown out.
No, what I did was I hired an attorney because you were saying you served me the subpoena that you never served.
And that was found to be valid.
You never served me a subpoena that was never, you never served me.
Oh.
I've never seen a subpoena from you from those addresses that you said you served. Those are not my addresses.
Your testimony said you have never been served to appear in court.
Objection,
I've
that's an
served- I've
answer.
never-
Sustained. Excuse me, sustained.
And so, with regards to your feeling threatened on them, have I ever any sort of physical violence against you?
No.
Do you have any written threats from me?
It's intimidating. You've intimidated me this whole time. As of now.
And in terms of your participation in this case,
Yes.
you understand that you were served a subpoena to appear here today.
You served a subpoena after you arrested me.
And
You served
you
a
have-
subpoena at the jail when I was in Broward County.
And you understand you were here pursuant to that court order.
I'm here.
And that requires, under the law, to comply with court orders and that compel attendance of witnesses.
I've been complying.
Okay. Nothing further.
So you can see how contentious it got. Let me ask you, Terry Austin, who came out looking the worst in this exchange through the course of the day? Prosecution, defense, or the witness?
Definitely prosecution. I think the witness is trying to avoid answering questions. Clearly, her memory is at a loss right now. But I think that the prosecutor was going way too hard on her and attacking her and definitely intimidating her. If you listen to what the prosecution was saying, Prosecutor Bradley, she's basically saying, look, I didn't physically threaten you. I did not verbally threaten you. But the fact that, she's arrested, that she's under house arrest, that she's wearing an ankle bracelet, that she was subpoenaed, she had to come in there. She's arguing with the witness, and the judge had to admonish the prosecutor. So I think the jury's going to look at all of that and determine at the end of the day, okay, I would be afraid too if I were the witness on the stand. And I don't like the prosecutor for beating up this mother of the, girlfriend of the defendant.
Yeah, and already it's the dynamic's weird. It's the mother of an ex-girlfriend. I've never had an ex-girlfriend, of course, but, I would imagine that, it creates some tension there, regardless of the fact that, oh, by the way, this is a double murder trial. Hey, Bryson, let me ask you this question, and I'll ask it in the context of what you're feeling there on the ground. Now, this is from Harry, 856-2667. Harry, I would caution you not to use your Social Security number in your ID there. Was the prosecution case weaker than originally anticipated? What's the feeling there on the ground?
Great question, Harry. Well, we got to say yes, indeed, especially on day 4 when the prosecution took on Felicia Holmes, who is also the mother of the ex-girlfriend of YNW Melly. Now, the prosecution thought they had a big card in Holmes testifying, thought they were going to play it, but things definitely did not go the way they planned, as Holmes definitely thought, or they thought Holmes would deliver a desired testimony, but it must have got lost at the top, because Holmes came into the courtroom like she ripped it off the plastic and she was acting brand new. She came and took the stand, put it all on the floor, had a verbal exchange between herself and the prosecutor, and definitely became hostile. And the prosecution asked her to be treated as a hostile witness. And even though she was treated as a hostile witness, she still held her ground, still remained unknown about everything that the prosecution threw at her. And then this visibly showed the prosecution getting beside themselves and becoming unprofessional, as many in the court recognized. And then on top of being subpoenaed, Holmes said she was threatened by the prosecutor herself, and literally said, "You ruined my life." On top of that,
I was going to say, but that is such a powerful moment. What was the actual reaction in the courtroom? Was it audible? Was it what was the sense there?
Well, for Melly, he definitely paid close attention to Holmes on the stand the whole time, and you could see a definite appear of sigh of relief for him, as Holmes became very uncooperative with the prosecutor, and often looked at the jury every time she made an answer for her statement with a "I don't know" and a direct "I was told to be here." And she actually not admitted, but she told that the prosecutor lied about ordering her to court, and threatened her life, saying she would throw her in jail if she did not appear in court.
Yeah, that's not really the best way to start that relationship, but understandable. Okay, so this question, it's a good question because I got to put my glasses on here. This is from Jenner BP from Instagram. This is Terry. This is a big one. Can the prosecutor be sanctioned for her performance yesterday, and Can the female defense attorney find herself in a bind because of her embarrassing behavior with the defendant? Like the stupid journal she held up in front of their faces for all the world to see. Inquiring minds need to know, says Jen Herb, BP.
Good questions. I'll start with the defense first. I think the behavior of the female defense attorney is really abhorrent. The fact that she's sitting there, she's smiling, and they're talking and chatting, and they're not taking the case very seriously. And as the attorney for Melly, she should be saying, look, so far the case is going well. So far the prosecution hasn't proven anything. Just remain calm and collected. Just don't have, any outbursts. Don't laugh. But instead you see her actually laughing. So I think that that is not doing well for her client there. She really should be advising differently. As far as the prosecution, yes, I think she could be sanctioned for what she's done there. The judge specifically told her not to put in any information from the statement in 2018. That's one of the issues factually that we're talking about here. There's that 2018 statement and there's a 2022 deposition, and the judge basically said, don't make any statements. You can't read into the evidence anything that she's not allowed to say. And he had already ruled that those pieces of information aren't coming in. So she could be admonished for that. She could be sanctioned for that. And, she absolutely could get a mistrial. That's the bigger issue. So I think both of the attorneys that we're seeing on both sides really are, having difficulty being upfront and being, straight in that trial.
When we see Melly and counsel just yucking it up there at the table, that is just so inappropriate and stupid. The jury's watching everything you do. And if they see you in a trial in which you're charged with 2 murders, just having a hell of a time, laughing, joking with your attorney, if the playing field begins even, you're going backwards. You're going to have to overcome that at some point. And I'm not even sure how you do it because it makes it look like you take the whole thing as a joke. Anyway, another question here. Let me ask you this, Bryson. This is from Kat Ritter from YouTube. What do you think about the talk about gang affiliations there? What was the reaction, and was there a problem when that was talked about? Because for those who may have missed some of this discussion, this was effectively an argument being made that Melly was trying to become a member of the Bloods and therefore was trying to impress people, and they're obviously at loggerheads with the Crips. And so that became part of the discussion in court. What was the reaction to that, Bryson?
Well, the prosecutor definitely used that in the opening statement. She said that Melly was recruited by the United Blood Nation and the G-Shine Bloods, but at the same time, there was no proof that shows that Melly has any gang ties, while he is being that is the reason why he's being put for the death penalty, is because they believe the death of Juvy and Sakchaser was because of a gang affiliated call. So
yeah,
there's no proof that YNW Melly isn't. The
suggestion has been, that was, he's proving he's making his bones there to take a mob, characterization. He impressed somebody, so he's going to knock off a couple of folks that he had a friendly relationship with, and that's going to endear him to the Bloods, and he'll rise in that gang. But very interesting, Bryson, that at this point we haven't seen a lot of evidence of that, just the suggestion that was a motivation. So we're going to take a break here. Good stuff, guys. More questions and probably more answers. So if you haven't done so yet, YouTube, Twitter, and all of those things, whatever social media you like best, send us your questions. We will try to get to as many as we can. Right now, a quick break. We'll be right back. This is Law and Crime. back to Law and Crime. Michael Bryant here. We're doing the questions and the answers as they relate to the Jamell Demons case out of Florida. This is a double murder case. Death penalty is on the table. The up-and-coming rapper, who I must correct myself, was arrested at age 19, not 18. Birthday's May 1st, I understand, according to my sources. Anthony Williams, Christopher Thomas both died on that night, October 26, 2018. There was a shootout. The question is whether it was initiated by, carried out by the defendant, or whether it was some sort of unrelated drive-by. So let's get to a couple questions. This one, boy, Terry, this one is fact intense. Are you ready for this? This is from, let's see, Daryl Vizzy from YouTube. The question would be, did they get the clothes Melly wore at the time of this incident, and why didn't the driver and or Melly get hit if there was a drive-by? They only shot the back and the right side. The sides those boys entered were shot up, and the back was shot up, and not one bullet hit the left back passenger and or the driver. How is that possible?
Well, the prosecution is probably asking the same thing. I'll address the latter question first. If, in fact, they were in the car and the car was shot up and there are bullet holes in all of the seats and on the outside, it's a very good question. You would have thought that Melly and the co-defendant, whose case has now been severed, Henry, would have had some blood on them, would have had some bullet shots, and would have had some injuries, but no, they did not. So I definitely think that that is an issue in the case. As far as the clothes, they were collected, but we saw that during the investigation, they weren't sampled for any gunshot residue, so not much happened with the clothing, but it was collected.
Yeah, we know there was a ton of discussion about the gunshot residue, which is kind of a red herring. That stuff, you can go by somebody's house and they've had a collection of guns. You might get some gunshot residue on you. It's just that easily transferable. Okay, let me ask you, Bryson. This is for an update, basically, because people are wondering, how long is this thing going to go on? We've heard various dates. What's your latest intel from the courthouse?
Well, as far as the duration of the case, we definitely have to find out on Tuesday, when it's up to the Judge Murphy as he makes his ruling on whether this case will receive a mistrial or whatnot. But if it doesn't, we've had multiple ideal dates. The prosecution says that the trial will end July 10th. The defense believes the defense believes that it'll end on July 19th, but the sheriff told the intern yesterday that the trial could go as far as August, but it's really up in the air right now based on
you're right.
The move for
Bryson, this could be over on Tuesday. You're absolutely right. But if not, it could be over in August. So that's almost helpful. We're hanging in there for the duration, whatever it might be. Thank you, Bryson. I appreciate that. Quick break coming up here, but before we do, here's a tease from Terry. The severance issue. Big deal in this case. We'll talk about it in a little bit. What do you think? Is it helpful?
I think it's a big deal. I think they can now point the finger at each other, which we've seen a little bit of.
Okay, we're going to talk about that and many more questions that are pouring in. Please send your questions. We'll get to the answers as we continue to talk about this case out of Florida, the double murder. It is Jamell Demons. It is Melly, the rapper. We're going to come back, talk all about it with your questions and answers right after this. Stay where you are. afternoon and welcome to this very special edition on Law and Crime. I'm Michael Bryant. We are looking at the case out of South Florida. Thank you for joining us for the YNW. Oh, I said it. I was supposed to take judicial notice. This is the Melly case. We've got Q&A from folks across the planet. So if you've not done so yet, please send us your questions on all of your favorite social medias. The court dark today, but we are catching up on what has been a crazy first week. It is expected to last at least another couple of weeks. This is where the rapper, whose real name is Jamell Demons, he's on trial in Broward County, Florida, accused of a double murder, charged with 2 counts. First, the 2 friends, I guess I'm going to call them. I don't think that's disputed. These shooting deaths in 2018 included the death of Christopher Thomas, also, he's known, by the way, as Juvy, and Anthony Williams, also known as Sakchaser. They're in this car after a recording session. It's like 4 in the morning, as I recall. And you see here the 2 defendants. One of them is not, those are the victims, I'm sorry. We have 2 defendants, but they're not both at the table in this particular trial, because Cortlen Henry has been severed, as they say. His case will be tried separately at a later date. We're going to talk about the importance of that decision and how it affects the arguments being made by all of the parties, both prosecution and the defense. So this guy, Melly, really a rising star in the hip-hop scene. And now, if he's convicted, there is the possibility of the death penalty. So we are taking your questions and providing answers. Luckily, I've got a great panel here to help do that. But before we get back into the questions, some of the testimony from yesterday, really a good part of the day, came from the mother of the defendant's ex-girlfriend. So let's listen to more of this testimony. Then we're going to talk and answer your questions on the other side.
Can we clarify who he is, Jameson Francois?
Just clarify, counsel.
So it's clear, who is Jameson Francois?
Please track, he's Melly's manager.
And you mentioned his wife as well. Who's his wife?
I used to go by AA.
So AA and his wife.
We're all good friends.
So I'm going to show you now what's been previously shown to defense counsel and marked as states triple M. It's a composite of 17 pages. Did you have an opportunity to review that prior to coming into court today?
Yes, I did.
Okay. And in terms of the individuals and the phone numbers that are on that, do you recognize your own phone number?
No, I do not.
Okay. Going forward through the contents of that particular item, do you recognize a conversation about a snake?
No, I do not. I know they had a snake, but I don't recognize this conversation.
Okay. With regards to the conversation about the snake that you do remember, what do you remember about the snake?
That they had a snake.
What happened to it?
Objection. Relevance.
Sustained.
So, Ms. Holmes, I want to ask you a question as to what was your daughter's phone number back in October of 2018?
I have no idea. I don't know.
Is there anything that would refresh your recollection as to what her phone number was?
No, because I don't remember mine.
You don't even remember your own?
Yeah, no, I don't know.
In terms of, did you review your statement of December 12th of 2018? Did you review that statement prior to testifying today?
Yes, I did.
And in that statement, were you asked, what is your daughter's phone number?
Objection.
Overruled.
I don't remember.
If I were to show you the statement, would that help refresh your recollection as to whether or not you were asked that question?
I don't think you would, no. But you can show it to me.
Ms. Holmes, when we left off, we were talking about a pet snake.
Yes.
Do you remember there being a pet snake?
I remember you talking to me about it yesterday.
Okay. And with regards to that snake, you recall it unfortunately passed away.
I'm pretty sure probably, I'm not sure it's not here, I'm pretty sure.
Okay. Do you remember the name of that pet snake?
No, I don't.
And in terms of the owners of that snake, do you remember who owned it?
I just know it was, I don't know who the owner was. It was in the house with Mariah lived.
Okay. Where did Mariah live at that time?
She lived in Myanmar.
And do you know the address?
No, I don't.
Who did she live with?
She lived with a boyfriend, but you know.
Okay. Are you telling the ladies and gentlemen of this jury that you don't remember your phone number in
I'm
October
telling you guys,
2018?
I do not remember my phone number. I don't remember.
And are you telling the ladies and gentlemen of the jury that you don't remember your daughter's phone number?
No, I do not remember my daughter's phone number.
And there's nothing that would refresh your memory or recollection whatsoever?
Objection,
That's
asked
4 years
and
ago.
answered.
Overruled.
That was 4 years ago. I've had so much trauma in my life since then.
Of course. Is it fair to say that you were worried about Melly when you came down here to Fort Lauderdale on October 26, 2018?
Was I worried about him? Yes, I was.
You were worried about him because he had just been involved in a drive-by?
No, because they said his friends had been in drive-by.
Okay. And you were worried about him because he was hiding in some bushes?
Objection.
I don't remember him being in
Sustained.
bushes.
Okay. What do you remember?
I sustain the objection.
What do you remember?
I just remember him saying for us to come get him.
When you made contact with him later that same day at Frito's house,
Yeah.
is it fair to say he had no blood on him?
No, he didn't have any brother.
And is it fair to say that he left Frito's house and went up to a video shoot that afternoon evening?
Yes, he did.
Did you go to that video shoot?
No, I didn't.
Did Mariah live with Mr. Demons after the homicide for a period of time?
Yeah, she did.
Did she live in a condo in Miami with him?
Again, that is the mother of the ex-girlfriend of Jamell Demons. And joining me, quite the gathering we have here as we address your questions and talk about this case out of Florida. Terry Austin still with me here in studio, Law&Crime's very own. We have Offie Patterson joining the mix. She is, we're talking about specializing here. She is a hip-hop, rap hip-hop expert. I mean, it's a finite, you come out of law school, you know nothing. And all of these little subcategories start arising, and I'm fascinated by this expertise, which is perfect for this trial. Bryson Paul, of course, has been covering the case for us in Florida. He joins as well. Let's jump into these questions here, and let me ask Terry this first question. This is the severance question we kind of teased going into the break here. Why were the co-defendants not tried together? This comes from Secret Smiler. And seems like it could have been stronger to prove they conspired to lie about the drive-by. So why the severance?
Well, oftentimes cases are severed because you will have conflicts if they are tried together. And when they are severed, they can actually point to each other as far as who pulled the trigger, who actually committed the crime. So I think it's going to work to each of their advantages to have separate cases. It's a little more difficult when they're both sitting there as co-defendants and then they both are saying that neither one of them did it. I think if the defense for Melly can point to the defendant, the other defendant, it's definitely going to be helpful. So the case was severed and they're moving forward, and we will at some point see the case against Cortlen Henry. They are making references to Henry in the case though, so it's not as though they're not mentioning him. So the jury has an understanding that there's someone else who is also being held responsible for this case. He doesn't have the death penalty, but Melly does have the death penalty against him.
Which leads to a couple of other questions. But yeah, when you have the severance, you can do this. This guy did it during trial 1, and then this guy did it during trial 2. So it does give the jury a little something extra to deal with. Okay, let me ask you, Offie, this question having to do with the demeanor of the defendant in court. This is from, let's see if I can get this right here. let me try. I think it's Orland. Okay, let me. Is that what it is? Okay. The question seems to be, what's wrong with Jamell Demons being kind of happy for his family and the support he's getting, rather than being kind of down and maudlin about the case itself? They're basically defending what we've somewhat criticized, and that is what seems to be kind of a jovial spirit during this very serious trial.
I think that's okay. Orland, thank you for the great question. I think this is a perfect example of why defense attorneys often advise their clients not to take the stand, because from the moment that they set foot in the courtroom, they're under so much scrutiny. They're under just a high degree of observation. So anything they do, anything, it could be super ultra normal for us, but we look at it and say, okay, that's a little off. He's walking weirdly. Okay, his gait means that he's untruthful. It's just everything is open to interpretation, but it's at a high level of scrutiny, and it's often slanted negatively. Also, he's been in custody. Prison isn't the easiest place to be. So when you're out and you have freedom and you're not cuffed and you're in regular civilian clothing, you might act a little free than you have otherwise been acting when you go home every evening, or how you have been since you've been in custody for the last X number of years.
Yeah, I just think I think people's reaction to his reaction, it being so extreme, is I understand maybe this is nervous for him, but it just looks more than nervous. It looks more like I'm taking this kind of lightly. But it was very interesting to hear one of the viewers suggest that maybe that's innocent, maybe that's not a big deal, maybe it's not as big a deal as somebody might think. Okay, Terry, let me ask you. This is from Forgotten Fits from YouTube. And I think it's a reverse question here. It says, could they use this against him? But then I think what are talking about is he was also convicted of discharging a firearm in public, aggravated battery, and 2 counts of aggravated assault. Of course, talking about Jamell Demons. Could they use those prior bad acts against him?
Well, that's something that the judge is going to ultimately decide. If he hasn't already, I think it's out at this point. So when you have prior bad acts, only if there are certain circumstances can that be put into evidence. And here the judge is going to look at, is it more probative than it is prejudicial? And if it has nothing to do with intent or plan, as far as this case is concerned, the judge is going to keep it out. So those charges don't have anything to do with the charges here. If it does come in, I think it will be prejudicial. So for those reasons, I think the judge is probably going to keep it out.
And that's typical. I mean, the standard is very clear. Unless you can prove some sort of connection, as in a pattern or some sort of signature, these are totally unrelated. You can't use prior bad acts to show somebody did something in the subject trial that's in front of the jury. Okay, I have to apologize to Bortlen because I got his question or her question wrong. So I'm going to give that question now to Bryson, and that question was: do they have any gunpowder inside the car? Were there any findings like that, Bryson?
Yes, they do have. They do have discovered gunpowder throughout the vehicle, but they do not have a concrete evidence of where the gunpowder comes from and whose hands it was on. As they explained, as the firearm expert explained, the disperse of a bullet distributes gunpowder residue, but it goes all over. And then somebody could easily just walk in the car and touch the gunpowder residue and have gunpowder residue on their hands. Not to say that they fired a gun and definitely killed somebody, or just fired a gun in general. So, but in correction, Mike, this is a big case because the case is between best friends. Now, Melly has referred to Sack and Juvy on multiple occasions, and in an interview and on music as his brothers, let alone his twins. And then he's not serving prison time. He's in jail. He's been in jail for the past 4 years.
So yeah, that gunpowder, there was an interesting demonstration done by prosecutor Kristen Bradley, where she was talking about how a golf ball will travel this far, and dirt will travel this far, and then soot will travel. And so it gave the jury some sense of what this whole gunpowder residue evidence is going to be. A great idea to do in the opening statement. Whether it plays out and puts it in the right places for this jury to find this defendant guilty is a whole other story, but I think it was fascinating for her to discuss it. And we know, as we talked about so many times, it's very easy to transfer gunpowder residue from one person, one piece of clothing, to another. Not conclusive. It's just all part of the mix here. Okay, I have something here from Linus Mumford from YouTube. Let me ask you, Afi, about this. Was it proper, and we've heard so much reaction to the testimony of Felicia Holmes, was it proper for the prosecutor, Bradley, to continually threaten Felicia Holmes with the possibility of perjury during the cross yesterday? I thought that was very harassing, says Linus Mumford.
I think, hi Linus, thank you. Linus sounds like a Leo, so am I. I think that it just lends so much credibility to the fact that she said that she felt threatened. She felt threatened by the state, and it just lends so much credibility to her claim that They threatened her daughter with arrest. They threatened to, hyperbole, ruin her family. She had an ankle monitor. So she basically felt coerced into making the statement. So I think that was just I don't think it was maybe the best idea, but it was a great demonstration for the jurors to see how she may have felt. And it just, to me, it just added just a lot of strength to her position.
Yeah, and the threat of perjury is always very dramatic, even though I think we all know in reality it is very seldom charged. It is threatened a lot, but very seldom charged. Okay, we're going to take a break here. Let me leave this question for you as a tease into the break. From Billy the Kid from YouTube, will Cortlen Henry testify against Melly? We'll take a break. We'll come back and answer that question for you. This is Law and Crime. back to the Law&Crime Network, everybody. Michael Bryant here. We are continuing our discussion of the case against Jamell Demons in Florida. It is a double murder case, and we have our Q&A panel ready to go. We kind of teased a question going into the break. Terry Austin is here, of course, Law&Crime's very own. Afi Patterson's here, an attorney and an expert in the hip-hop legal ramifications of that very unique world. And also, of course, Bryson Paul. He is on the ground there in Florida, been following this case from inside the courtroom. So I'm going to ask you this, Bryson. Going into the break, we were basically asking the question which was sent in by Billy the Kid from YouTube. Will Cortlen Henry, remember he's the co-defendant but being tried separately as a result of a severance, will he testify in this case against Melly?
Bang, bang. I can definitely say that YNW Bortlen will most likely not testify in this case, as he is also on trial and also has the chance of incorporating himself involved as being the person that did these actual murders instead of Melly, which is what Melly's attorney is trying to prove right now. Now, Bortlen is also set to have a trial based on the similar case, and he's while not seeking the death penalty from the state, he's seeking life in prison, or they're seeking life in prison at that. Now, this is a very important case for not only the state of Florida but hip hop in general, as it's celebrating its 50 years right now, and already has 3 death penalty cases a part of its history.
Boy, that's a fascinating little tidbit you just happened to throw in there, Bryson. And I want to clarify for the audience, if they heard me say Cortlen Henry and they hear you say Bortlen, let me just give you my take on why that dual name comes up. As I understand it, if you're connected to the Bloods gang, you don't use the C letter because that's connected to the Crips. Therefore, any word that begins with a C, you replace with a B. Therefore, Cortlen becomes Bortlen. Do I have that right? I think I have that right. Okay, so in case you hear it said one way or the other, that's the reason. Before we get back to some of these questions here, we have a very interesting piece of tape for you. This is Anjanette Levy's interview. As you know, Christopher Thomas Jr., better known as Juvy, was one of the victims in this case. Well, Anjanette had the chance to talk to his father, Christopher Thomas Sr. Let's watch.
Chris was a good kid. He's the second of my oldest boys. He's the oldest of his mom's kids, and he loved his whole family. He loved all his friends, and he just got caught up for being too loyal and got betrayed by one of his so-called friends. It's a sad situation for everybody. I met Melly around like 99, like a couple years before Chris met him. I was friends with his Melly's mom, best friend at the time, and that's how I got to know Melly. Then Chris got to know him after that. They was all good kids coming up, just laughing, playing, joking with each other, having fun, like to hang out with each other, and he loved them boys, and he loved them to a fault.
So he was friends with them since they were little kids then, it sounds like.
Yes, ma'am. They went to elementary, middle school, high school, all together. That's how I know his mom as well, and his stepdad and the rest of his family, Melly's family. And the music started, I think, around 2000, maybe 13.
And they were just all making the music together?
Yes. Started from rapping at school until making music together and coming up with the name, the YNW, and it just went from there. And Sack and Chris and Melly and even Jay Green was all founder members of the YNW. Melly was just the face of it. I say now that Chris and Anthony is gone, now he just took everything over. From the day one, I believe that Melly was responsible for my son's death on October 26th when I first heard the story, because his explanation, when I finally talked to him and Cortlen on a FaceTime, their response and how they was reacting, they showed no remorse. They didn't act like they was grieving, like they lost a best friend or nothing. They was, in my opinion, they was in the best spirits. They never came to town, never came to my son's funeral, never came to Sack's funeral. And these are best friends. He passed straight through the county of Indian River, went to Brevard and did a music video, but he couldn't even stop and pay his condolences to his best friend's mom. He even got Jana tatted on his neck. That's why his defense attorney got him wearing turtlenecks and shirts to hide his neck, because he got the Jana tatted on his neck. That's Sack mom's name, and he got Chris' name and Sack name. And this guy, that guy is just, I have no words for that guy, man. Nothing was said. Actually, it was like the demeanor. It was like the body language, really. Like, I was just reading them, and as I'm telling them and asking them questions, I got so emotional, I started crying. They wasn't reacting to, they acted like they didn't have take a loss at all. That's how I took it. And then when I was talking to them, I still had in the back of my mind that something's not right. Something's not right.
Did they tell you anything about what they claimed happened with the drive-by they claim happened?
No, they had absolutely no explanation. Like, we had to figure it out just like the police.
Chris, why do you think that this happened? Why do you think, Melly did this? Because, Melly is on trial. The state has to prove it beyond a reasonable doubt that he committed these crimes. But why do you think this happened?
I think the story about the $200,000 with Anthony was a true story, because it's not reported, but Chris told me the same story, and also it was a $500,000 play, and Melly was going to get $200,000, Sack was going to get $200,000, Chris was going to get $100,000, and as I'm hearing it from Chris, they was going to sell the YNW brand, not a record deal or nothing like that. It was like for the brand itself, and by them being founding members, they was going to get a piece of the pie. So I don't think Melly did it on his own. I think that manager guy got in his ear and did a little divide and conquer. Because if it was up to Sack, it would never be $100K management.
They were going to sell the YNW name for licensing or to sell products? Or what do you mean they were going to sell the name?
For marketing, licensing, stuff like that. I think they want to go up on the big umbrella just to push them, I think. Push the brand more global. That's what I'm thinking.
And so you think that Melly wanted a bigger cut of that then?
I think Melly didn't want to give them guys nothing. He wanted to be the only one to shine. And then they came to town next day and gave the mothers $15,000, the other mother $10,000. So I thought to myself, if Sack was going to get $200,000, Chris was getting $100,000. If we could pay these people $25,000 and keep $275,000, that's how I saw it. It just nothing added up. And Melly still to this day for me to hear him call them boys his best friend is an insult. That is an insult. I think it's going pretty good. It's just a long process. Just got to trust the process in my book. And I think she's doing a good job. I think once the ballistic, the forensics, the cell phone, and when it showed that Chris got shot on his left cheek and the back wrist, he got shot from this side of the car in his left cheek with stipling on his face and the burn marks on his face from the gun muzzle. All that's going to point in the one direction to that guy that was sitting in the back driver's side. And
Christine Bradley, the prosecutor, had said yesterday that the medical examiner is going to testify that before the shots were fired into the vehicle, that your son and Anthony, they were already dead. When those shots went into the vehicle, they had already been shot, and the fatal shots came from the back seat. That's the testimony that's expected.
Yes, ma'am. From my understanding, yes, the shot that Chris left cheek was the fatal shot that took him out. And then when he staged the drive-by, the shots from the back, they could tell by the way Chris' body was slumped over how, like, it was staged after the fact. Yeah, that's going to come out. I can't wait. That's going to be like breaking news. It was Chris wasn't killed in the drive-by. I know that for a fact. Yes, eye for an eye. Old Testament. I think he deserved it. Because they show no remorse. They still trying to badmouth these boys. And when it happened, Melly and Kristen had Instagram pages. He went on his page. They went on his page. Whoever took all the pictures down of Chris and Anthony and made it look like they was never existed. If he's so innocent, they never put up a reward to find the killer. They never did a tribute. They never did anything. They even pushed Chris' funeral back from 11 a.m. to 2 p.m. just so Melly could make it, and he still didn't show up. And he never showed at the Sack funeral. So this your best friend, and you don't even come to the funeral? I don't know, man. That guy deserves everything coming his way. And I have no sympathy.
And so much good stuff in that interview from Anjanette Levy of the father of Christopher Thomas, one of the victims in this case, known also as Juvy. I mean, everything from the fact they were great friends to the point that, according to Dad, money motivated the death of his son and Anthony Williams. I mean, this is amazing stuff, and we'll see it as it continues to unfold. Again, the court is dark today. We're taking your questions, providing a few answers along the way as we wait for them to come back into session, assuming the mistrial motion is not granted. I'm going to take a break, but let me plant this in your brain here. Bobby Renee says, do you think Melly taking the stand will help or hurt him in his situation? We'll take a break, come back, talk about that and more on Law&Crime. Law and Crime. Hey, if you haven't done so yet, get at the keyboard there and send us your questions regarding the Jamell Demons trial out of Florida. He's accused in the multiple shooting deaths of Anthony Williams, Christopher Thomas Jr., buddies apparently of his in the rap world, and prosecution says that he turned on him. We just heard some very interesting stuff from the father of Christopher Thomas Sr., interviewed by Anjanette Levy. And there's so much going on in there. I want to ask my guests here. Terry Austin's here. Also, Afi Patterson is here. She is an attorney and an expert in this hip-hop world. And also at the courthouse, Bryson Paul. So, Terry, just give me your takeaway from that interview with the father of one of the victims.
Well, two main takeaways, Michael. First of all, he is really not happy with Melly and the way Melly is acting, not just in the courtroom, obviously, but prior to that when he didn't go to the funeral. I mean, it seems as though he was personally hurt by his inaction, by not coming to the funeral, by not expressing any grief, any remorse. And then the other main takeaway from that interview was there is a motive maybe here that we heard from Christopher's father. The motive might have been financial, and oftentimes it is financial. Now, obviously we know prosecution does not have to show motive, but if in fact they were going to sell their brand, the YNW brand, and get money for that and, sell it for licensing or marketing, and, Melly wanted to make more money and he could make more money if there are less people to split it. Well, I mean, that's a motive. So those are the two main takeaways, but I thought he was really being very forthright. Great interview there.
It really was. Let me follow up with that with you, Afi, because, this hip hop world is your expertise. We're talking about big money in these licensing deals, in the music deals. Does this make sense to you, this story that we just heard from one of the victims' parents, that kind of money was being tossed around or at least talked about?
Absolutely. And you're correct. In the hip hop world, just in the music entertainment industry as a whole, there's money in licensing. It's not going to necessarily be in your streams anymore. So I love that he brought that up. And I think it's also interesting because I think we heard yesterday that Kevin Liles is going to testify. And I believe he's the CEO of the label that they were involved with. I think it's 300 Entertainment. So I look forward to see how the prosecution is going to handle that. Also, I think that something the prosecution hasn't done yet is lean into motive. As Terry said, motive is not an element of the crime, but we all want to know motive. We all want to know why. It can be as simple as we got into a fight the day before. It can be as simple as a money issue, but we need to know. And I think that the prosecution needs to focus on motive because I think they did do a great job establishing that I think Sack and Juvy were killed from inside of the vehicle. And they need to lean into the fact that the drive-by was staged. It was a conspiracy, and it was a conspiracy hashed out of a motive for more money.
We see this quite often, these acts after the fact that seemed like a great idea to the defendant at the time to either cover up a crime or create an alibi. This was pretty elaborate. And if there's no forensic evidence to support that drive-by theory, I think that may be enough to give this jury a reason to convict, just because it makes it seem even more devious than the original crimes to go that far to create this alibi. Hey, let me ask you this question. This was what I had mentioned before going into the break. I'm going to give this to you, Afi. This was Bobby Renee. Do you think Melly taking the stand will help or hurt him in this situation?
It depends on what he has to say. Only Melly knows that. Only his defense counsels know that. I think it's really challenging when a defendant takes the stand because, again, they're under such heavy scrutiny. So, even his walk to the stand, people are going to scrutinize that. When he starts answering questions, they're going to say, okay, is he whispering? Why is he not speaking up? Or is he speaking too loudly? He looks remorseful. Does he look remorseful because he's guilty? He doesn't look remorseful. Does he not look remorseful because he's trying to portray that he's innocent and not guilty? I mean, anything you do is going to be questioned, and it just depends on how the observer is leaning, how their pre-existing feelings, and if they're swayable or not. So it's just never a good idea. But in addition to that, there's so many things from a defendant's background that may be brought up. A defendant also may open the door to evidence that isn't admissible, but because he mentions it, you can now open the door to it and the prosecution can attack it. So it's not always advisable to have the defendant take the stand. But the bigger question is going to be, why is Bortlen not taking the stand? Because he's available, he's out there. The jury for sure is going to want to know why. Why isn't the prosecution calling him? And hey, why isn't the defense calling?
And you just wonder how sophisticated the jury might be. I mean, each person's a little different, but I think many of them will process it and say, well, what's he going to say that doesn't hurt him in his upcoming trial? So it would be, kind of a difficult position he'd put himself in. Maybe the jury figures that out, maybe they don't, and they hold it against the prosecution for not putting him on. Again, we're taking your questions today as we talk about this case out of South Florida. It is a double murder case. It is a death penalty case, at least as it relates to Jamell Demons. So, Terry, let me see. I've got one here for you. I made a circle on this one here. Oh, was there anything found? This comes from it. Now, it could be at Demon, or it could be pronounced differently. So it says it Demon from YouTube. The question is, was anything found on Jamell Demon's clothes, like DNA?
Well, based on what I heard, I think it was not anything that was conclusive. They found, gun residue, they found some DNA, but nothing that said that, specifically either Melly or, in fact, Henry could have been responsible for this crime. So I thought the prosecution spent a lot of time with experts going through what could have been possible with DNA, giving us lessons about, the gun and the DNA and the trajectory and the trajectory. I mean, it just was a lot of information, but nothing very factual. At the end of the day, when you came across at the end of the prosecution's case for those experts, I didn't come across with anything conclusive as far as the DNA was concerned.
Yeah, and it's obviously a lot still to play out here. We're 4 days into trial. They're off today. They'll be back at it on Tuesday. There's the holiday on Monday. So what we like to do? We like to look ahead. So I've got a question for you, Bryson. We're far from this particular question, but this is from Talia Murray from YouTube, asking, is Fredo going to testify? Fredo going to testify? Do you know anything about that?
Actually, great question. Actually, there has been no documentation that shows that Fredo will testify, even though he has been mentioned several times as one of the people that Melly was with that morning of the murder. Now, it's being accused that Melly used him as a scapegoat, but it's no confirmation, and there's nothing that proves that Fredo had any involvement in this incident or anything anything around it. So we haven't gotten any clues, haven't gotten any documentation from the defense or also the prosecution. So we just got to wait and see. But I can definitely say Bortlen will not testify because it's a 99% chance that he'll plead the fifth.
Okay, well, if Fredo has nothing to say to hurt himself, maybe he will testify. Terry, here's a question from Champion. Do you think, this is really looking down the road here, do you think Melly would get the death penalty if convicted?
I don't. First of all, we have to get him convicted. The prosecution has to prove their case beyond a reasonable doubt, and so far there is plenty of doubt for this jury. They haven't really put the gun in his hand. They really haven't put him in that car shooting from behind. We'll see what the future evidence might be. I mean, we heard the father talking about the gunshot to the head, the death shot. So maybe at some point they will. But even if he is convicted, they're going to have to prove aggravating factors, and some of the aggravating factors I think might be difficult. Was this heinous? Was it cold? Was it calculated? Some of those might exist, but I think the death penalty is reserved for those really atrocious crimes where there are multiple victims, even more than 2 victims, and where the crimes are so heinous that they're involved with rapes, etc. Not that being shot to death isn't heinous. In fact, as far as I'm concerned, all murders are heinous, but I don't think that we'll get the death penalty. If you think about the Nicholas Cruz case, that case, he did not get the death penalty, and there was nothing more heinous than that crime.
And there was a lot of outrage, too, because people were saying, if not then, when? And it's so interesting now. We know the death penalty requirement for the jury decision is different. They've waffled back and forth in Florida. It used to be didn't have to be unanimous, and then just a few years ago they changed and said yes, it must be unanimous, and now they've gone back the other way. Afi Patterson, what do you think about just that procedural wobbling in Florida?
I think it's up to the people. I'm from Louisiana, my home state, and for a while, I think to convict, you only needed 10 of 12 jurors. And recently, it's now you have to have a unanimous verdict. So it's just, the will of the people, and it's different state to state.
Yeah, now in Florida, it's hard to keep up, but now it's 8 out of 12. If 8 out of 12 vote for the death penalty, that in fact is, it shall be imposed by the court, and that's critical to the legislative language. It's not a question. He has no discretion. He has to impose it if the jury votes for it. Okay, so let's take a break here. Again, we're handling your questions, and we're going to continue to do so as we move through this hour. Stay where you are, or hit the keyboard at your favorite social platform. Send us your questions. We'll be back right after this. back to Law and Crime. Michael Bryant here. We were just having a very spirited discussion. Terry Austin's here, Afi Patterson is here, and Bryson Paul is here. He's from the in the courthouse. Our spirited discussion had to do with the alibi, as it were, about the drive-by and who was in what position in the car, and if Melly was truly in the rear left position, how did he not get shot by those in the drive-by, or did he somehow move, or did he get in a different car? All of these things that have yet to be discussed, at least to my satisfaction, and probably the jury's, but will unfold over the days. So let me give you this question. Let me start with you, Terry. This is from KJ from YouTube. If Melly claims it's a drive-by, okay, what explains the gun residue on his clothes? And then there's kind of a separate question. Either one of them had to do it and not snitch, or both, and that referencing, I believe, Cortlen Henry. So what's your take on the physical evidence if the drive-by really happened as the defendant suggests?
Well, he could have gun residue on his clothing because gun residue is very tiny particles and they could be all over the car. So I think that the gun residue itself isn't definitive one way or the other. So for that, I think it could have been either one of them and they could have been in that car. Now, the issue really is, how were they not shot? Not so much the gun residue, but why weren't they shot?
Yeah, if they were in the positions, we were just talking about this, if they were in the positions that we believe, as Melly was in the passenger seat behind the driver, the shooting comes from that side, the bullets, they stop, jump over him, and hit Anthony Williams and Christopher Thomas Jr. That just doesn't make sense. You have to believe he changed seats. That's the only way that makes sense, or was in an entirely different car, which is also something we've heard is a possibility here. Okay, let me see what else we can squeeze in here in the last little bit of time we have here. This is from XXLT Demon X. The question is, did they, and this is for you, Afi, did they identify the driver? If so, did he testify or no?
Hi, XXLT, is that right? From what I understand, the driver is Mr. Cortlen Henry, and he is also being charged with murder, and the cases have been severed. Usually cases are severed when there are adverse defenses where one defendant's defense is going to conflict or be adverse to another defendant. So that's usually the reason why cases are severed. But he was the driver, and I've always said, I think jurors and I think audience members, as yourself, want to know if he was there, he's one of the survivors of this alleged drive-by, why is he not testifying? Let us know. Anybody who's involved in who outside of the defense, the defendant, we want to hear from. So, but yeah.
Yeah, and to our discussion about who was where when, if he was in fact driving, Cortlen Henry, again, the bullets would have had to jump over him to get to the other passengers on the other side of the car. Okay, Terry, here's a question from Australia, okay? This is top of the morning. Do they have to prove Melly pulled the trigger or just that he was present?
Well, I think it would be better for the prosecution if they could show that he pulled the trigger and they're asking for the death penalty, and that is why they are asking for the death penalty. And I think for the jury to convict, they're going to want more evidence that he was the one who actually pulled that trigger. But there's a person, two people who are dead. And so if they don't actually show who pulled that trigger, the jury could theoretically still come back with a conviction.
Okay, well, it's time for our lightning round as we wrap things up here. Here, just a very simple question at this point in the trial. Start with you, Bryson. Who is winning?
Right now, it's up in the air. It's definitely a chess game, but we have
Come on, make a decision. Let's go.
Tuesday.
What is it? Come on, yes or no? Prosecution, defense.
I'm not making a decision. I gotta let you guys know. It's
way
a court
too neutral.
It's a court case. It's
Terry
not what
Austin,
you know.
who's winning at this point?
At this point, no doubt the defense is winning. They've put on a good case, started with a strong opening, and they are doing great crosses, and they are really making great motions.
And Afi Patterson, what do you think?
I also think that, I hate to say the word win, but I think the defense is up right now. I think the prosecution has lost a little bit of credibility.
All right.
And I think they also need to lean into
Despite one abstention, we have
drive-by.
2 for the defense. I would agree with the defense as well. We're going to take a break. We're going to come back more out of Florida. Thank you, everybody, for being here with a Q&A. We'll be right back. afternoon. Welcome back to the Law and Crime Network. I'm Michael Bryant. Hey, it was good to get the little Q&A out of the afternoon session. I hope you enjoyed that. We had so many questions, and it's always good to see what's going on inside the minds and the keyboards of those folks around the world, really, that are watching this case. If you are just joining us, our eyes, ears, and most of our body parts involved. The Broward County, Florida case is the trial. The trial we're watching is the Jamell Demons trial. He's better known by his stage name, Melly, the YNW part. I am taking judicial notice of that. I may not mention it at all times. But Demons is charged 2 counts of first-degree murder in the deaths of 2 of his buddies. This happened in 2018. Christopher Thomas Jr., also known as Juvy, Anthony Williams, also known as Sakchaser. They're all in the rap music business. The defendant and the victims, all part of this collaborative that was involved in hip-hop. So we have a second defendant you're not going to see at the table here, Cortlen Henry. He was in the car that night. He has been charged, as has Jamell Demons. He will be tried at a later date. And by all accounts, Melly was really a rising star in the hip-hop scene. Now, if he's convicted, this 24-year-old does face the death penalty. Court dark today. They'll be back at it Tuesday after the holiday. Critical witness on the stand yesterday. So we're going to talk more about it, but let's first listen to some of the testimony of the mother of the defendant's ex-girlfriend. This is Felicia Holmes.
Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, you know, I don't feel comfortable.
Are you nervous?
I feel threatened.
So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jamie.
Had you met her prior to October 26th of 2018?
Yes, I did.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to.
I don't know, but I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about early morning hours. Did you receive or hear a phone call or a FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, do you remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. I don't remember what I said at that. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So, in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter and take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't remember.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
Objection, asked and answered.
Excuse me, overruled.
So, Ms. Holmes, did you lie to law enforcement?
Not that I recall.
Okay.
I don't remember.
Okay. Going forward to the events of that day.
Yes.
When you heard that phone call, where were you?
I'm home.
Okay. Where was home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone that was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
In terms of the method of communication, do you know if it was a FaceTime call?
I assumed it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 through December of 2018, do you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding that phone number, was that saved in your phone at that time?
It may have been. I can't remember.
Do you remember what phone number you had?
No, I don't. No, I don't.
So, Ms. Holmes, to go back in terms of looking at your statement or any of the other things, refresh your recollection as to what the defendant's phone number was and what you had at that time.
I'm sorry, could you repeat the question?
Sure. You said you didn't remember the defendant's phone number.
No, I don't.
Would looking at a copy of your statement help refresh your memory as to what?
No, I don't think it would.
Okay. Would you like to try to do so?
You have to look at it for you, sure.
Ms. Holmes, prior to that deposition starting, were you given your prior statement to review?
What you mean?
Were you?
I understand. The deposition that I did on December 22nd? Yes,
Yes.
It was given to my lawyer yesterday, right before. Briefly to look at, yes.
Okay. So the deposition you have, that was
It was
provided
given to my lawyer
your-
yesterday, yes it was.
Okay. So, do you remember coming in for that deposition?
Yes, I do. I was in jail, put me in jail. Yes,
Correct.
I remember.
And so it's clear in terms of you don't want to be here.
You're making me be here. Yes, I have
Yes.
a house, a band on my leg. I'm a nurse. I can't even work properly. Yes.
You were under house arrest because you failed to comply with the subpoena?
No, you did not serve the subpoena.
Sustain. Listen, how we're going to do this is you ask your questions, counsel, ma'am, listen to her question, answer her question.
Yes, I am.
All right?
Yes, sir.
Thank you.
Okay. So going back to the deposition.
Yes.
On December 14th of 2022.
Yes.
Do you remember coming to my office?
Yes, I do.
Okay. Do you remember being asked questions at that time?
Yes, I do.
Do you recall being given a copy of your prior statement of December 12th, 2018?
No, I don't remember that. I don't remember changing, but I'm pretty sure I did.
Okay, so what I'm going to do is permission to approach her on it?
With what, counsel?
Her deposition.
Objection, Your Honor.
I have to give her an opportunity to...
I saw my
Excuse me. There's no question pending review. All right, you can proceed, counsel.
Okay. So, counsel, I'm showing her page 10, line 10 through 17. Okay, so just read them silently to yourself. So back on December 14th of 2022, were you asked if you need to make any corrections or deletions to the statement of December of 2018?
That's what the deposition said, judicially.
And did you indicate that there was no corrections or deletions in those statements?
I don't remember, but that's what's on the deposition.
Okay. So, December of 2022, you said that this was a correct statement.
Objection.
Sustained.
So, Ms. Holmes, is the December 2018 statement that you gave correct and honest?
Objection. Asked and answered.
Excuse me. You have to let, I don't understand you're trying to answer the question, Ms. Holmes. when they raise an objection, let me answer the objection first.
Yes,
all right? Objection notice overruled.
We need to see the witnesses as well as hear them in those cases where we've only had the audio. Man, what you're picking up on the nonverbal there is amazing. And this thing continued. Again, this was the mother of the ex-girlfriend of the defendant. And you could just tell the the bristling began, and ultimately she was declared a hostile witness. Hey, bordering me here, I have a couple of great guests. I have Dr. Joni Johnston. She is a clinical and forensic psychologist, also an investigator. And Kathleen Bogenschutz is here. She's a criminal defense attorney. Thank you both for joining. Appreciate it. This is the first time we've had a chance to talk about this case. Let me start with you, Kathleen. The consensus after week one is that the prosecution might be struggling a little bit. What's your take on their presentation of the case?
So, just as a disclaimer, I know all of the people involved in this case incredibly well. I did the first 9 years of my career in Broward County as an assistant state attorney. So I actually came up with the prosecutor. I was able to watch the video of that cross, and what struck me were the comments, because I love reading the comments. And it gives you an insight as to what maybe your jury might be thinking when you're at the courtroom. So pretty much everyone hated the way that she went at this. It's incredibly frustrating to have a witness that's this combative with you. Of course, it sounds like she got a lot of evidence in as to what the prosecution did to try to get her here. And that's a double-edged sword, because it could be that, they look at the prosecutor as a bully, or it could be that they're thinking to themselves, if she really didn't want to testify, what does she know? So it did somewhat seem like she was struggling, though. I'll give you that.
Yeah, interesting, very unique insight there as to the players in this, because most of us see them, in this venue and don't have any real backstory. So it's interesting you have that to provide. Let me ask for the mental element here as the mental health professional, Dr. Joni. What do you see play out? Let's just talk about this interaction between the professional and the witness.
Yeah, I mean, the first thing that I think a lot of people were thinking is this is the prosecution's witness. I mean, that's something that it's very clear from the very beginning. You could turn the sound down, as you mentioned, Michael, and get a pretty clear picture of how this witness feels about being there, which is not happy, angry, hostile, etc. And I kind of felt like as the testimony went on that the witness really, in a lot of respects, kind of gained the upper hand. And then, you had this series a little bit later on where the judge is sustaining objection after objection, and it really did become kind of a battle of wills almost. And again, I kind of felt like the witness was winning.
Yeah, and the jury, when they're watching this, whether it's the prosecution coming off as we think this prosecutor did, or the defense, the jury's factoring that into the mix. And you really don't want to be the focus of the, if you're the counselor, you don't want to be the focus. You want that witness to be the focus. You want that witness's testimony to be the focus. And I think they definitely went a little bit adrift here. Okay, guys, stay where you are. Going to take a break, talk more about this case. They are dark today and Monday for the holiday, back at it Tuesday, measuring a mistrial motion. That'll be the first order of business Tuesday morning. We're going to talk about that and much more when we come right back to Law&Crime. somebody offered you a chunk of money, would you lie on the witness stand? Would you maybe have a convenient lapse of memory? I don't know. But in this particular case, again, we're in Florida for the case against Jamell Demons in the death of 2 fellow rappers. On the stand is the mother of his ex-girlfriend, and she was downright not happy to be there. She admitted that. But why would she have the testimony she did? Could it be because she was paid by somebody? I mean, could that happen? Let's listen now to some more of her testimony in this case.
Can you clarify who he is, Jameson Francois?
Just clarify, counsel.
So it's clear, who is Jameson Francois?
He's Nelly's manager.
And you mentioned his wife as well. Who's his wife?
I used to go by AA.
So AA and his wife.
We're all good friends.
So I'm going to go through now what's been previously shown to defense counsel and marked as states triple M. It's a composite of 17 pages. Did you have an opportunity to review that prior to coming into court today?
Yes, I did.
Okay. And in terms of the individuals and the phone numbers that are on that, do you recognize your own phone number?
No, I do not.
Okay. Going forward through the contents of that particular item, do you recognize a conversation about a snake?
No, I do not. I know they had a snake, but I don't recognize this conversation.
Okay. With regards to the conversation about the snake that you do remember, what do you remember about the snake?
That they had a snake.
What happened to it?
Objection. Relevance.
Sustained.
So, Ms. Holmes, is it your statement, testimony, that you never stated the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies? They didn't want us talking with prosecutors, but now they've all disappeared. You've never said that before.
I don't remember saying anything like that.
Objection, Your Honor. Move for a mistrial.
Thank you.
Ms. Holmes, did you ever say the defendant made you quit your job?
I never really say anything like that. I don't want to ever made me quit my job.
Objection.
If I may approach him? I'm going to show you this next few minutes. Okay. So, Ms. Holmes, I'm going to ask you again. Have you ever made a statement that the defendant made you quit your job and that they would take care of us until the trial was over?
I don't really say anything like that.
Okay. So you're denying making that statement?
I don't really say anything like that.
No.
Objection. Your Honor, can I just have a standing objection so we don't keep interrupting?
You stay with your heard on the standing objection?
Whatever defense chooses to proceed.
Go ahead.
Okay. No. So, Ms. Holmes, in terms of have you ever said a statement, have you ever made a statement to the effect of you were told to quit your job and the defense would take care of us?
Objection.
No.
Excuse me.
The defense? No.
Much comes out.
Ms. Holmes, I want to ask, were you present when your daughter spoke with law enforcement?
She was 17 and I had been present.
Oh. Do you recall about when that happened?
If she was 17, that had to happen in 2018.
Okay. Without getting into what she said on that. Do you remember where that statement was taken?
No, I don't.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Demons?
Objection. Calls for a conclusion on part of this witness.
Based on your daughter's demeanor, how was she acting?
Sustained.
When you arrived in Fort Lauderdale and saw Mr. Demons, did you ask him what happened?
Objection. Asked and answered.
Overruled.
I'm sorry, repeat the question.
When you arrived in Fort Lauderdale, did you ask Mr. Demons what had happened?
No, I did not.
Nothing further.
Well, we are not getting along in that courtroom. And as you know from yesterday, yesterday afternoon culminated in a motion for mistrial by the defense based on the testimony of this witness that the defense says got into areas she shouldn't have because the prosecution kind of worked her around one way, that she got in some stuff that maybe she shouldn't have. The court has taken that under advisement and will make a decision before they begin again on Tuesday morning. Odds on, the money says probably not going to end in a mistrial, that the court would basically take the risk that if there is a conviction, that'll be handled on appeal. So Dr. Joni Johnson is here, also with me Kathleen Bogenschultz. So Dr. Joni, put on the mental health professional hat for me if you could, and give me your take on here. You have a witness who clearly doesn't want to be there, doesn't really like anybody involved, and would rather be anywhere else. If you're sitting in this jury and you're trying to read this person, give me some help on what you see coming from her.
I mean, it's a very difficult position to be in. You're up there and you're trying to get information. You started asking some very basic questions like, do you believe that you told the truth, a few years ago? And somebody goes, well, I would hope so, or whatever, which you're expecting. Most people would say, yes, I think I did tell the truth. Maybe they might say later on that, oh, maybe I misstated or whatever. So right off the bat, you have somebody who is clearly not going to be cooperative and then tries to interject or does interject things like I was bullied and my daughter was threatened and those kinds of things. So you really are in a very difficult position. And I think if you're the jury, you are closely watching to see, especially when you have a witness who's saying things like I was bullied and those kinds of things. I think once the prosecutor starts talking about receiving payment and some alternative explanations as to why she might be hostile to the prosecution, that's different from her being mistreated by the prosecution. I think as a juror, I think my ears are going to pick up and I'm going to go, okay, maybe there's more than one explanation for why this witness is so clearly unhappy to be here and so clearly evasive and, having a very, very convenient memory.
Follow-up question on that. All things being equal, do human beings as jurors, do they want to believe the witness? Do they want to believe the prosecution? Or are they totally neutral?
I think most jurors, pride themselves, whether they really, in their heart of hearts are that way. I think they really do pride themselves on thinking of themselves as objective parties initially. They've been asked that prior to being selected for the jury. So they're going in there thinking, okay, I'm going to be an objective party. Now, they're going to start hearing different people. They might like some people more than others, find others more credible. Obviously, their own values and beliefs are going to creep in, because that's we're human. And we are going to, interject our values and beliefs. But I think most jurors do think of themselves as being as neutral as possible. And then everything else is going to be based on facts, which, of course, a lot of times are interpreted by emotions.
Yeah, it is fascinating, the dynamic between them and how the jury is going to, evaluate that in the big picture. Kathleen, as I mentioned, this back and forth and this witness's testimony ended the day with a motion for mistrial. Rarely are they granted, often are they requested. What's your take on this one?
I actually think that it's possible that the judge is trying to teach the prosecutor a lesson by saying, here's a 3-day weekend. Why don't you spend your weekend worrying about it before you start questioning somebody again? I agree with you that I think it's unlikely to be granted in this scenario. But even I was annoyed hearing the back and forth go, and even just watching it on the screen. It's incredibly annoying to hear objection, and then she asks the same question, and then objection, she asks the same question, she changes one word. And I have to imagine that if I'm feeling that way, the jury's feeling that way too.
Yeah, all the stops and starts, and they just want to hear the story. Just, can I hear the story, please? And we'll find out Tuesday if they're going to continue to hear the story. I think also a motion this early in the process is even far less likely to be granted because there's so much to come. In fact, here's some more of what they heard. This is more again from Felicia Holmes, the mother of the defendant's ex-girlfriend. Here we go.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Christine.
Your Honor.
What the rules?
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
You said you feel threatened by me.
Of course.
Okay. Did you fail to appear for numerous court appearances?
No, you never served me. Lied.
Okay.
You lied to the court.
And with regards to, did you work in Redding, California?
Yes, I did.
Okay. Material.
Overruled.
And so that was a location you were at?
That's where I was chocolate nurse at. Yes.
Okay. And in terms of the prosecution You have been served on various occasions to testify.
You served me a subpoena on November to be the next week, and I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in February of 2019.
You never served me. You served it to a location I didn't live at anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Anything about the courthouse tonight?
Excuse me, come sidebar.
You even went so far as to hire an attorney to try not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. If I could go to my job with this, it's embarrassing. People think I'm a criminal. The state has run my life.
And in terms of your feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
and does that influence your testimony today?
It's not influencing my testimony. I'm telling you.
That's not,
I don't understand.
Excuse me, hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, Your Honor. So that my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued, you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you at the 4th District Court of Appeals?
He had to hire an attorney because he tried to get him this far.
And no, that's a false statement.
Objection.
Excuse me. Counsel, you're not testifying.
I
all right?
agree on that.
Excuse me. You ask a question, all right? That's it. You ask the question.
And so, Ms. Holmes, with regards to that, you hired an attorney?
Yes.
And you then tried to get any sort of court order requiring you to be here in court thrown out?
No, what I did was I hired an attorney because you were saying you served me the subpoena that you never served.
And that was found to be valid?
You never served me a subpoena that was never, you never served me.
Oh.
I've never seen a subpoena from you from those addresses that you said you served. Those
So
are not my addresses.
Your testimony is that you have never been served to appear in court?
Objection.
Sustained. Excuse me, sustained.
And so, with regards to your feeling threatened on them, have I ever any sort of physical violence against you?
No.
Okay. Do you have any written threats from me?
It's intimidating. You've intimidated me this whole time. As now.
And in terms of your participation in this case,
yes.
You understand that you were served a subpoena to appear here today?
You served a subpoena after you arrested me.
And
you served a subpoena at the jail when I was in Broward County.
And you understand you were here pursuant to that court order?
I'm here.
And that requires, under the law, to comply with court orders and that compel attendance of witnesses.
I've been complying.
And nothing further.
Wow, the defense counsel like whack-a-mole, they're popping up and down at every moment. For the jury, they get confused about what this is all about, and the substance of the witness's testimony gets kind of lost in the shuffle. But this is a murder case, and Jamell Demons is looking at the possible death penalty. We'll come right back to this case out of Florida after this. Law and Crime. We continue our coverage of the double murder trial out of the South Florida area. Jamell Demons, a.k.a. Melly, a rising rap star, now a defendant accused of killing two people he worked with, also in this kind of a little consortium, I guess they'd come up with. YNW was kind of an acronym they used to identify their group. Well, now two of them are dead, and the defendant says it was a drive-by he had nothing to do with. Prosecution says, no, you did it, and so did your buddy Cortlen Henry, who will be tried at a later date. So this is the first of two trials related to these murders. Dr. Joni Johnston is here. She's a clinical and forensic psychologist. Kathleen Borgenschutz is here as well. She's a criminal defense attorney. Thank you, guys. Always appreciate the insights. In this case, boy, it's really getting the attention of not just the hip-hop world, but folks who are being exposed to it, which I think is very interesting. Kathleen, what's your take on that? This is a look into a very different world for some folks, and I have to say, myself included. You know, this is not a normal day for me to hear this kind of, not just the crime, but the lifestyle. What are your thoughts on that?
Yeah, and when you look at the evidence in this case, you've got maybe a statement by the this current defendant that says, "Shh, I did that." Shh. But and you think to yourself, who would brag about having committed a homicide if they didn't? And I'm sure that's going to be what the defense says in this case. I mean, if you are making a living as a rapper, yeah, some kind of street cred, absolutely.
Exactly. Yeah. So I know that little tweet, I think it was, that said, that was me. Right. Dr. Joni, that seems kind of kooky, as Kathleen suggests. Would you say that if you didn't do it? And would you do it if it really gave you, in the rap business, that, as she says, the street cred is, is it that base?
Well, I can't say that I've evaluated a lot of rappers who've been accused of crimes, but I have evaluated hundreds of gang members. And absolutely, these are some of the stories I hear over and over again. It is a different world in a lot of respects, and there are different rules, and there's a view, I think, oftentimes, and I'm talking again about gangs versus some different rappers, but there is some parallel in terms of the street cred, and sometimes bragging about things that you didn't do, which I've certainly heard, and of course, doing things that you did do that do give you some sense of power, prestige in your neighborhood, can protect your family to some extent. And so, it doesn't surprise me that their possibility is raised that, this person really didn't do it. He's just bragging about it because he's going to make him seem like a bad person, like a person who's really living his lyrics, I guess. Yeah, and that the prosecution has certainly used that as insinuated it. I'm sure we'll hear much more in the form of testimony suggesting that was the deal. He was kind of up for membership in the Bloods. Again, that's part of the story, and it's a big story. But yesterday's big story was this interaction between the witness we've been watching, the mother of the ex-girlfriend of the defendant, which led to a motion for mistrial because of some of the testimony she presented. So what we're going to do now is take a look at that motion. This is outside the presence of the jury, and you'll hear how upset the defense is about what they say the prosecution has done. And again, this is the motion now pending before the court. We won't know till Tuesday morning how the court rules, but let's listen to how this thing started to boil over.
Jury's been excused. Counsel remain along with defense. So you have a couple motions for mistrial. You want to talk about those?
Yes, sir. As sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that was what the state intended to do, advanced a ruse, pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to Plan 1, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Demons has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial. And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text, couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since, so just to let the court know there is no factual predicate for the implication, or not implication, the accusation made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
With regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good exception to all the rules of evidence, and there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or Mr. Demons' interests have been irreparably prejudiced before this jury.
So the crux of this mistrial motion is that the defense has been besmirched by the prosecution, suggesting through this witness, Ms. Holmes, that the defense was going to take care of her. And yet each of the attorneys said, I never even seen this woman. What did the one attorney say? Wouldn't know her from a can of paint till today. So there was some evidence in the record that the witness had suggested she had been advised by somebody at some time that she would be taken care of. Interesting. You know how you can get a mistrial? Well, death of a juror or an attorney, not the case here. This is the Florida law. Impropriety in the jury selection process not discovered till during trial, or a fundamental error unfair to the defense. That's part one, and cannot be cured by an appropriate instruction to the jury. That's part two. I'm going to talk to my guest about that when we come back. Let's take a break. Come back. This is Law and Crime. back to Law and Crime. Michael Bryant here. Good to have you along as we get ready to launch into a holiday weekend. Hope you've got some plans in store. So we're getting ready by digging into this hip-hop case that has had some very interesting procedural maneuvers. We're only into the fourth day. It should continue for a couple of weeks. Now we're looking at a motion to dismiss. This is the case out of Florida against Melly. That's his stage name. Jamell Demons is the man's name. 24 years old, accused of killing a couple of folks he knew well, friends with, had a musical connection, but then things kind of went awry. If you believe the prosecution, is because he just killed them on October 26, 2018. Shot them while they were leaving the studio, heading somewhere, or was it a drive-by? That's the real question in this case. Dr. Joni Johnson is here, also with us, Kathleen Bogenschultz. I'm going to break down my setup into the break with a two-part question here. Let me start with you, Kathleen. The first part of this mistrial question for the judge is: was there a fundamental error that was unfair to the defendant? What do you think? Yes or no?
I shudder to say yes, but I think they did cross the line there, trying to backdoor in things that the judge had already said was out. And the question is, can you remedy it with an instruction? I would be interested to see what kind of instruction the judge puts together. For the prosecutor, I would. If I were the prosecutor, I'd be really concerned about the contents of that instruction, because I'm assuming it will say something to the effect of, you should really disregard anything that the prosecutor tried to put into evidence and reduce her credibility. And there's also the concept in Florida of goading, G-O-A-D-I-N-G, a mistrial. So if the judge were to grant a mistrial, I can guarantee you that prior to the second trial starting, that the defense would make this argument that the state knew things were going south and that they goaded a mistrial, meaning they tried to cause one so that they get a second bite at the apple and start over.
That's so interesting. And and thank you for stealing the second part of my question, which I was going to give to Dr. Joni. But like a good attorney, you anticipated that and you gave me the answer. And you're right. I mean, that is almost, to suggest the prosecution would go that far really would mean, man, we're getting pounded here. That's a tough one. So let me ask you, Dr. Joni, from a psychological perspective, as the jury is watching this unfold, how does this factor into their, they're hearing, they're not hearing the mistrial motion, but they're hearing what led up to it, and it doesn't look good for the prosecution.
It doesn't, and it's interesting. I really appreciated Kathleen sharing that Florida law, because I had no idea that there is such a thing as goading, because I did find myself thinking as I was watching this motion that, wow, would it be a bad thing for them to have a do-over? And so it's really interesting that that accusation could be out there if it was to be granted in another trial. So, I mean, if you're the jury at this point, I can't imagine what you're thinking. I mean, everything we've watched today, since I've been on here, has had nothing to do with the actual trial. The facts or the evidence or anything to do with murder. And so, I think I would be thinking, what is going on here? And when you have not only, this prosecutor getting so many, objections that they're being sustained, it does start feeling like that, she is bullying.
Yeah, and it takes the jury out of the case. That's the bottom line. Well, this is going to continue, and I'm going to thank and excuse both of you, Dr. Joni, Kathleen. Thank you so much for being here. Appreciate your insights. I'm Michael Bryant. Hey, try to do the right thing. Have a great weekend. We'll see you next time right here on Law and Crime.